Okay, good morning, everyone. So today I'm going to go over some housing updates. I'm going to try to do it as quickly as possible. We're each allotted about 20 minutes or so, so I'm going to try to give as much of an overview as I can. So to begin, we'll start with legislative updates. Okay, so my apologies if that's too small. I thought I made that font bigger. So with the legalization of cannabis, we have this new section of the Residential Tenancy Act, section 21.1, and this deals with cannabis smoking. So basically, in terms of the definition of cannabis, it has the same meaning as in the Cannabis Act. And then you can see there listed those 4 points below kind of define what is cannabis. So for existing non-smoking clauses, they will also apply to cannabis smoking. So if a tenancy agreement was entered in prior to the legalization of cannabis, which was October 17th, 2018, and had a no smoking clause, it would include smoking cannabis, but not vaporizing cannabis. So if there's a no smoking clause, vaping is completely fine. They don't consider that to be smoking cannabis. All existing tenancy agreements will be deemed to include a non-grow clause unless the tenant is authorized under the applicable federal law to grow medical marijuana, the tenant is in compliance with the requirements under the law, or the tenancy agreement specifically allows for growing. We also heard a bit of positive news in regards to the rent increase. Most of us will probably agree that the limit of the annual allowable rent increase is still too high. But nonetheless, they did get rid of this additional arbitrary 2% that they were applying to the annual allowable rent increase. So now, rather than the annual allowable rent increase being the rate of inflation plus that arbitrary 2%, they have eliminated that 2%. So now the annual allowable rent increase is limited to inflation. And so this can be found in section 22 of the Residential Tenancy Regulation. It was effective January 1st, 2018. And then section 32 of the Manufactured Home Park Tenancy Regulation as well does limit the annual allowable rent increase to inflation and the proportional amount. So in terms of notice of rent increase, so pursuant to section 22 subsection 4 of the Residential Tenancy Regulation, if a landlord gives a notice for the annual allowable rent increase with an effective date after January 1st, 2019, before the change took effect, and use the old rent increase formula, which was again the inflation rate plus the 2%, the landlord must issue a new updated second notice of rent prior to the effective date of the old notice of the rent increase with the new rent amount, which again is limited to inflation. Now the 3-month notice period does not apply to the new updated notice of rent increase. They just have to give notice with the new amount. So we've seen, so moving on to policy guidelines, we have quite a few new policy guidelines now. Most notably is the guidelines in regard to ending the tenancy for landlord's use. So previously we had policy guideline 2, and that encompassed both notices to end for landlord's use of properties for situations where the landlord was moving a close family member in, as well as renovations or repairs or converting the unit to non-residential use. So now that's been split up. We have policy guideline 2A and policy guideline 2B. So policy guideline 2A deals with ending a tenancy for occupancy of the landlord, purchaser, or close family member. So some of the changes that we see here, in terms of the good faith requirement, it's largely unchanged as compared to the previous policy guideline on this. So the landlord, good faith requirement means that the landlord does not intend to defraud or deceive, does not have an ulterior motive, and is not trying to avoid obligations under the RTA, such as an obligation to repair or maintain. If evidence shows the landlord has ended tenancies in the past to occupy a rental unit without occupying it for at least 6 months, this may suggest the landlord is not acting in good faith in the present case. If there are comparable rental units in the property that the landlord could occupy, this may suggest the landlord is not acting in good faith. And the onus is on the landlord to demonstrate that the plan to occupy the rental unit for at least 6 months and that they have no ulterior motive. And that 6 month is tied to tenant's compensation, which I'll get to a little bit later. But this is why this is now included in the new policy, this requirement that the landlord occupy the unit for at least 6 months. So in terms of occupying the rental unit, this is interesting. Occupy means to occupy for a residential purpose. And this is a result of a case called Schuld and New, which I will speak about a little bit later on. But occupy has always been an undefined word as far as the Residential Tenancy Act is concerned. It was always very unclear if that meant that the landlord actually had to reside or occupy it or use it as for residential purposes. And now because of this case, we have some clarification, and we know that occupy does mean that the landlord or the close family member or the purchaser has to occupy it for residential purpose. The landlord or close family member can also intend in good faith to use the rental unit as a living accommodation or as part of their living space. So what that means is if a landlord is occupying the main floor of a home and they want to now occupy the basement suite, which is a rental unit, they can do so. They can sort of reclaim the rest of the housing unit or the rental unit if they're only using part of it. So in terms of vacant possession, Policy Guideline 2A also states that a landlord cannot end a tenancy to occupy the rental unit and leave it vacant and unused, except in extenuating circumstances. And in extenuating circumstances would mean basically that the landlord or the purchaser was prevented from doing what they said they were going to do within a reasonable period after the effective date of the notice, the stated purpose for ending the tenancy, or if using the rental unit for that stated purpose for at least 6 months duration, beginning with the reasonable period after the effective date of the notice. So there is these extenuating circumstances that landlords will be allowed to claim if they don't do what they say they were going to do within the 6 month period. So consequences for not using the property for the stated purpose. So under Section 49 of the RTA, if the landlord has not taken steps to accomplish the stated purpose for ending the tenancy within a reasonable period after the effective date of the notice to end tenancy, or use the rental unit for that stated purpose for at least 6 months, beginning with a reasonable period after the effective date, the tenant may seek an order that the landlord pay the tenant additional compensation equal to 12 times the monthly rent. And this is finite. It's 12 months. It's limited to 12 months. They can't award less. They can't award more. It's 12 months automatically. And again, the landlord can be excused from these requirements in extenuating circumstances. Again, if they can prove that there was no way they were going to be able to do what they say they were going to do in the notice to end because of whatever reason. So Policy Guideline 2B, this is the policy guideline that now deals with ending the tenancy to demolish, renovate, or convert the rental unit to a permitted use. So it's split. The policy guideline is split up into sort of those main components that outline the statutory criteria to end a tenancy for landlord's use for these purposes. So one is the landlord is required to have all the permits and approvals required by law before they issue the notice to end. So the policy says that the landlord must have all necessary permits and approvals that are required by law before they can give the tenant a notice to end tenancy. If a notice is disputed by the tenant, the landlord is required to provide evidence of the required permits or approvals. The permits or approvals in place at the time of the notice to end tenancy issued must cover an extent and nature of work that objectively and reasonably requires vacancy of the rental unit. And if a required permit cannot be issued because other conditions must be met, the landlord should provide a copy of the policy or procedures which establishes those conditions and shows that the landlord has completed all steps possible prior to obtaining vacancy. And this might be a municipal bylaw that requires the landlord to take further steps before they can be issued a permit. Policy also states that the landlord should check with local governments to determine whether there are municipal requirements to undertake renovations and submit evidence of meeting those requirements. And I think, as most of us might be aware, there's a lot of municipalities who are actually trying to and have successfully passed bylaws that do kind of restrict the renoviction scenario. So I think that this portion of the policy acknowledges that the municipalities, various municipalities have enacted various bylaws that landlords should be aware of before they proceed with the permitting process. So if permits are not required for work, the landlord must provide evidence that permits are not required, but that the work necessitates vacancy. So if you have a landlord who's saying, you know what, I don't need permits for this type of work, they'll have to show proof. And that might have to come from a tradesperson, it might have to be a bylaw. They have to provide proof if they're alleging they don't need permits for a particular renovation or repair. And they also have to show that the work still necessitates vacancy. That's key to the notice to end for landlord's use for renovation or repairs. There has to be some evidence that the work does require vacancy in the unit. And permits and approvals can also include strata bylaw requirements and zoning requirements as well. So in terms of the good faith requirement, again, similar to policy guideline 2A, the good faith requirement is largely unchanged. Some examples of when the landlord would not be acting in good faith include if their intention is to re-rent the unit for a higher rent without completing the renovation or repairs. The landlord may not be acting in good faith if they have a history of ending tenancies for renovations or repairs that require vacancy if the renovation or repairs were never undertaken. So you can see in this language, the first instance, they say the landlord would not be acting in good faith if their intention is to re-rent the unit for a higher rent. And the second example is the landlord may not be acting in good faith if they have a history of ending tenancy. So obviously the second scenario is not as strong as the first scenario in terms of proving that the landlord's acting in good faith. So just to note that, the language is a bit stronger for the first scenario. And so if the landlord is planning to undertake repairs or renovations and claims permits are not required, this raises the question of whether the landlord has a good faith intention to renovate or repair the unit in a manner that requires vacant possession. So these are arguments that you could certainly bring to the RTB during dispute resolution if you feel that the landlord does not have a good faith intention to undertake certain repairs or renovations or to convert the unit into non-residential use. So this policy guideline also expands upon demolition. So the definition of demolition pursuant to the policy states that demolition is the complete and irreversible destruction of the rental unit. Now this doesn't always mean the destruction of the building containing the rental unit. It may also involve partial demolition of the building so the rental unit ceases to exist. And there's no right of first refusal if the rental unit has been demolished for obvious reasons. But important to note that demolition does not include demolition of the entire building. As long as the unit no longer serves the purpose of a rental unit, then that will be also considered demolition. In terms of vacancy requirements, just keeping track of my time here. So I have about 5 more minutes, and I'm not really through all that I wanted to get through. The policy guideline changes for 2A and 2B are pretty significant. In terms of the vacancy requirement, there is a case called Barry and Cloette in British Columbia, and in this case, it states that the renovations by their nature must be so extensive as to require the rental unit to be vacant in order for them to be carried out. And vacant, pursuant to this case, means empty. We recently had a BC Court of Appeal case called Artie Investments and Bauman, and in this case, this case law has now become entrenched in the policy, so we know that the RTB is relying on this case law. So pursuant to Artie Investments and Bauman, the question posed by the RTA is whether the renovations or repairs objectively and reasonably require vacant possession. So where the vacancy required is for an extended period of time, the tenant's willingness to move out of the rental unit and return at a later date is not sufficient to establish whether the repairs or renovations objectively require vacant possession. So if a tenant says, you know what, I'm going to move out, renovations or repairs are going to take about 2 months, but I'm willing to move out, that's not sufficient. And that's what was argued in the Bauman case, and the Court of Appeal did not accept that, did not buy that. However, due to Barry and the case Barry and Cloette, I think there's still an opportunity to argue that the RTB arbitrator still has to consider a tenant's offer to move out for a duration of the renovations or repairs if it's for a short duration. Because in Barry and Cloette, that case, it was a short duration that the repairs or renovations were going to take place. So in that case, the court found that you did need to consider this offer to move out. So the question still remains open, I think, when you're dealing with renovations or repairs that are going to be short-term, require short-term vacancy. So I'll try to skip over a bit of what I have here and just get to some of the more important pieces. Okay. So that's all I'm going to say about policy guideline 2B. I want to skip over to policy guideline 27, which deals with jurisdiction. And the only update for this policy guideline is basically this guideline confirms that the RTB has no jurisdiction to resolve disputes between co-tenants, tenants in common, or roommates. And the tenant may be a landlord if they rent out the lower street of a residential house, but not a second bedroom in a building. So that does go to the definition of landlord and when a tenant may become a landlord. And so that last point clarifies that a bit further. Policy Guideline 39 has also been updated. This is the policy guideline involving direct requests, specifically in terms of adjourning hearings and reconvening them as participatory hearings. So this policy states that the director may adjourn the proceeding and reconvene it as a participatory hearing if they have questions about the evidence, which would best be answered through oral evidence. So the arbitrator can take it upon themselves to decide this needs to have a participatory hearing. We're not going to proceed through an ex parte proceeding. The director may also adjourn the proceeding and reconvene it as a participatory hearing if the director accepts the tenant's application seeking an extension of time once the direct request process has begun. The tricky part is your client, the tenant, knowing when the direct request process has begun, because there's no, it might be too late. The hearing might have already been scheduled. So if you have a client who's a tenant who suspects that the landlord might kind of take this route, you can always call the RTB to find out whether or not there are any applications for direct requests, because if the tenant does file an application during that process, the direct request process that the landlord's initiated, then the arbitrator will likely turn that into a participatory hearing as well. If the tenant files an application to dispute the notice, the direct request process is not available to the landlord. So again, might be good to get on top of it. Call the RTB if your client who's a tenant suspects that the landlord might be bringing forward an application for direct request, and then they can file their own application in order to make it so that this direct request process is not available to the landlord. And if the landlord issues subsequent notices and requests another direct request, such applications will be cross-heard at the same time as the tenant's application. So direct request process, there are instances where your client, the tenant, can take action to ensure that it converts to a participatory hearing. Next policy guideline that was updated is the policy guideline in regards to digital evidence. So this guideline just basically outlines formatting and file size restrictions, the maximum size for non-video files that can electronically be submitted is 10 megabytes. The maximum file size for video files that can be electronically submitted is 200 megabytes. The policy guideline also lists different formats that are not acceptable, so different file extensions that they will not accept, so you can refer to the policy for that information. And the next updated policy is the policy guideline 47, which is the access to records and information. Sorry about the double and up there, didn't catch that. But this policy guideline gives a bit further information about what information you can access and who can access that information from the RTB. That is my time for today. I believe that was the only, and then just to be aware, another policy guideline update is also the expedited hearing process. So now there is an expedited hearing process. This policy outline guides what needs to happen for that process. The expedited hearings are limited to just early ends to tenancy, order of possessions for a tenant, and emergency repairs. And I think that is it as far as updated policy guidelines are concerned. Now I guess I'll hand it over to Allison.
Thanks, Dana.